What does divorce look like if my spouse and I disagree on some issues? Hi, I'm Bill Farias, founder of Farias Family Law, and this is a very common question. Most people, thankfully, have not already been through a divorce, and so it's new and it can be scary, and you want to know what the roadmap looks like. What does this process look like? So the first thing that you need to do is you need to figure out whether you would benefit from consulting with an attorney. And the best mechanism for figuring out whether it makes sense for you to make that move is to figure out where you are on the risk spectrum. On the low end of the risk spectrum, you have a very short-term marriage, not many assets on the line, very little disparity in income, so there probably won't be an alimony issue, and you have no children, so you don't have to worry about child support, and you don't have to worry about custody. As you move down the risk spectrum, longer marriage, more on the line for assets, disparity in income, you have children, so you have to figure out parenting time, child support. As you move further down that spectrum, it makes more sense to at least consult with an attorney to size up what you have, what you should be looking for. And then, using the same analysis, you need to figure out whether it makes sense to actually hire an attorney. Again, this depends on what you have on the line. If there's very little on the line, it may not make sense. The more you have on the line, the more cost effective it is and the smarter it is to invest in an attorney. Next, there's sort of a fork in the road. So if there's a disagreement between the parties, some people opt to mediate. And that involves going to a third party, usually an attorney with some experience, and running the numbers by that person, running the scenario by that person, and that person makes an effort to guide the parties toward a resolution. Now, whether that is a good fit for you, again, depends on where you are on the risk spectrum. The riskier it is, the more that you have on the line, the more sense it makes to get the guidance of an attorney, even if you choose mediation, right? Because the mediator is not looking out for you. The mediator, certainly, especially if you invest in a good mediator, is going to do their very best to move you toward an agreement, but they have no obligation. In fact, it's a conflict of interest for them to actually advise you. So the more you have on the line, the more sense it makes to get that advice from someone who is in your corner. If you don't mediate, right, either because it doesn't make sense financially, you don't think there's a good enough chance of resolving it on your own, or you just want an attorney more involved and in control of the process, then you file the case in court. Another reason to actually file the case in court is to get things moving. If you're working just with a mediator, or even if you don't have a mediator and you're trying to negotiate, if you don't have something filed in court, that gives the other party an opportunity to drag their feet. And there are a number of reasons to do this. One of the most common ones is a party doesn't want to leave the home, right? They want to just drag it out as much as they can so they don't have to make a significant financial move and go find somewhere else to live. And there are a number of other reasons to do this. But if you feel like you're not going to make enough progress without an actual filing, and you want to make sure the other person has to come to the table and actually start discussing resolution, then that's a good reason to get the case filed, among many other reasons. But at the very least, if the case is in the court system, the other party has to participate. So once the other party is actually participating, then you have what I call the discovery phase, and that's just basically exchanging information. There's certain information that has to be exchanged in order for the judge to find later on that there has been full and fair disclosure and approve the divorce. And so you want to make sure that that information is available to both parties, and that the parties are comfortable that they've had or they have access to all the info they need to make an educated decision on how to proceed. Then you have negotiations, right? This is just kind of back and forth. There's some give and take in most negotiations. Most of the time, neither party gets everything they want. So there are negotiations. If the case is in the court system, you will have hearings whether it be a motion hearing where people are asking the judge to put something in place while the case is pending, or a pretrial hearing where the parties, usually through the attorneys, discuss ultimate resolution with the judge and get some feedback. If the case is not resolved during these preliminary hearings, then the case is scheduled for trial, which is the ultimate event at which the judge hears evidence and makes a decision on the issues that are contested. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.